Welcome back to the Deep Dive. Our mission here is always to take these complex, sometimes kind of obscure stories and, turn them into something clear and actionable.
Yeah, exactly.
And today we're diving into a story that is, I think, a perfect illustration of this. It's about how one tiny federal agency, one you've probably never heard of, provides this silent, massive economic infrastructure.
And what happens when a sweeping executive order almost dismantles it literally overnight?
It's a remarkable case. It really is. It serves as this powerful reminder of how the judiciary can act as a check, and not just on broad policy, but on the nuts and bolts of administrative procedure.
Right. We're looking at a single federal judge who effectively restored stability to the entire nation's labor market. It's a case that proves that, specific laws from Congress, these statutory mandates, they always take precedence over these sort of generalized executive directives.
Especially when those directives are executed in a way that is, well, frankly, arbitrary.
Completely arbitrary.
Exactly. So today we are focused on the decision from Judge Dream Subramanian. He's in the Southern District of New York, and this was handed down on December 30, 2025.
And this ruling just completely reversed what was, a near fatal blow to the Federal Mediation and Conciliation Service, the FMCS.
So our deep dive today is kind of threefold. First, we really need to understand the policy that kicked off this whole crisis.
Then we have to quantify the just astonishing economic value of this tiny agency. It's really incredible when you see the numbers.
It really is. And then finally, we're going to unpack the legal mechanics. We're talking about the Administrative Procedure Act and statutory interpretation, the tools the judge used for this dramatic reversal.
And for you, the listener, this is a crucial shortcut. This isn't just some niche labor story. It's really a masterclass in administrative law.
Absolutely.
You're going to walk away with a crystal clear understanding of what's called the arbitrary and capricious standard, how courts review these final agency actions, and why those dry old statutes from Congress, like the National Labor Relations Act,
Yeah, the ones no one reads.
the ones no one read, why they're the absolute final line of defense against the discretionary use of executive power. This case is just a clean, modern example of checks and balances working exactly as intended.
Okay, let's unpack this. We have to start with the initial shockwave, because these cuts, they weren't phased in. They were sudden, severe, and just immediately disruptive.
Right.
And it all stemmed from a presidential executive order that came out in early 2025. What was the core policy goal driving this whole thing?
Well, the overarching goal was a major, across-the-board cost-cutting initiative. The executive order mandated that all federal agencies had to reduce their overall headcount to the greatest extent possible.
To the greatest extent possible. That's pretty broad language.
It is. It was a directive to, slim down the federal workforce and, frankly, to show some visible compliance with a popular political goal of fiscal restraint.
That makes sense as a broad political objective. But the way the FMCS chose to comply, it was radical.
Yeah.
The scale of the reduction here, it really suggests they interpreted greatest extent possible to mean something like near complete operational shutdown.
Oh, the numbers are staggering. And they were a central point of the whole lawsuit. Before the cuts, the FMCS operated with a small, very specialized workforce, about 143 full-time federal mediators across the country.
Okay, so 143. These are the experts, the neutrals.
Highly skilled professionals. But after they implemented this new policy in March of 2025, that workforce was reduced to just a bare-bones minimum. We're talking 5 or 6 active mediators.
Wait, 5 or 6? For the whole country?
The entire country, yeah.
So they put 137 mediators on administrative leave. Just want to sit with that number for a second. 93%. That's not a statistic. It means an agency whose entire purpose is to prevent national industrial chaos was left with basically no capacity to do its job.
Exactly. You said it perfectly. It wasn't just a reduction in force, a RIF. It was a functional dismantling of the agency. When you put 93% of your key staff on paid leave, you're not cutting costs efficiently.
No.
You're signaling to the entire labor world that the federal government is functionally withdrawing from this critical role it's played for, almost 80 years?
But it gets worse, because the cuts weren't just about the people. They immediately rolled out these new eligibility thresholds that just, surgically removed federal help from almost every medium-sized labor dispute in the country.
Yes.
Let's get into those specific, really drastic requirements.
These thresholds, They really became the Achilles heel of the whole policy when it got to court. The
Right.
agency had to decide, who they would serve with their remaining 5 mediators.
And their solution was just to raise the bar so high that almost no one could clear it?
Precisely. They created 2 really distinct hurdles. For the healthcare industry, which is crucial, and as we'll get into, has its own specific legal requirements for mediation. For them, services were limited only to bargaining units with at least 250 employees. So if your unit had 249 nurses or hospital staff, you were completely out of luck.
Just cut off. And for everyone else?
For every other sector, manufacturing, transportation, utilities, you name it, the threshold was way more restrictive. Services were limited to bargaining units of at least 1,000 employees.
1,000. So an entire segment of our economy, representing hundreds of thousands of workers in smaller but still critical manufacturing plants or, regional hospitals. They were just immediately abandoned by the one federal service mandated to help them.
That's the practical effect. The policy just assumed that only the largest, nationally significant disputes were worth the time of their handful of mediators.
And that completely ignores the huge ecosystem of mid-sized bargaining units that really depend on the FMCS to avoid these disruptive, localized, but still very economically damaging work stoppages.
Exactly.
And this is where the immediate crisis started to unfold. This wasn't some abstract bureaucratic change. The sources we look at show real-world negotiations just collapsing instantly.
The chaos was immediate and it was visceral. The records submitted to the court, they show that multiple unions and management teams were forced to abandon their collective bargaining sessions mid-negotiation.
Mid-negotiation. Just imagine that scene. You've been in talks for weeks, maybe months. You're exchanging final proposals. The mediator is the one going back and forth, holding this fragile piece together.
And then that neutral party gets a call and has to say, "I'm sorry, I've just been placed on administrative leave. My services are withdrawn, effective immediately."
The mediator, the linchpin, the one person preventing the talks from devolving into a shouting match or just total impasse, simply vanishes. That's not just disruptive. That's an active guarantee of escalation.
It is operationally absurd. I mean, in labor negotiations, timing is absolutely everything. A mediator holds the keys to that room. They're managing expectations. They're translating legal jargon. They're finding that creative compromise nobody else sees.
Right.
And when you pull that structure out from under the parties, the negotiations don't just pause. They fracture. The immense trust you've built up, sometimes just to get to the brink of a deal, it's just destroyed.
And the immediate consequence of that fracture.
It was exactly what the agency was founded to prevent. An immediate threat of strikes and lockouts escalating across all kinds of industries all over the country.
So the unions that sued the government had proof of this.
Oh, yeah. Clear, documented injuries showing that without a neutral party, impasses were suddenly guaranteed to become conflicts. In the absence of a federal mediator, the next step is often the picket line or the employer locking the gates.
So the very act of trying to save a negligible amount of money by cutting a $55 million budget resulted in an immediate, exponentially larger threat to the national economy.
That's it in a nutshell.
And that realization brings us directly to why this tiny, obscure agency, the FMCS, is so incredibly crucial.
Precisely. We need to shift gears now and really dig into the economic footprint of this agency, because it's often mistakenly viewed as just, another piece of administrative overhead.
Okay, let's do a true deep dive into the FMCS itself, its identity, its role. When was it even established, and what makes it different from, say, the NLRB, which more people have heard of?
The FMCS was born out of the really profound industrial conflict right after World War II. It was established under the Taft-Hartley Act of 1947.
The Labor Management Relations Act, right?
That's the one. Its founding was basically Congress acknowledging that the government needed a dedicated, independent federal agency whose sole mission was prevention, acting as the nation's primary neutral mediator for labor disputes.
And that distinction from the National Labor Relations Board, the NLRB, is absolutely vital here.
It's a critical distinction. The NLRB is essentially the labor court. It handles the legal enforcement of labor law. It investigates unfair labor practices, it runs union elections, it rules on legal disputes.
They're the referee with the penalty flags.
A great way to put it. The FMCS, on the other hand, is purely about voluntary assistance, conciliation. They're trying to prevent the need for the NLRB's enforcement in the first place. They are proactive peacemakers. They work in a pre-litigation space, facilitating agreements rather than, adjudicating failures.
And their work is confidential, right?
Completely confidential, voluntary, and non-adversarial, and that's what makes them uniquely effective.
Okay, now let's look at the sheer scale of the workload they manage. Even with that small staff of 143 mediators before the cuts, this will help illustrate why 5 or 6 mediators is just. It's an impossible number. We have data from fiscal year 2024.
The numbers are extraordinary. In FY 2024 alone, the agency mediated 2,318 collective bargaining negotiation sessions.
Over 2,000.
Yeah, just think about that volume. 2,318 situations where labor and management are at a table hammering out a contract. Every single one of those is a potential flashpoint for a strike, and the FMCS was there, at the table, preventing those flashpoints from igniting.
That's a monumental amount of just foundational work. And that's only the contract talks. What about disputes that come up in the middle of a contract?
So that's covered by what's called grievance mediation. It's often more specialized. In 2024, they facilitated 1,362 of these high-impact grievance mediations.
And these are what? Disagreements over how to interpret the contract.
Exactly. Disagreements over interpretation. If those disputes are left to fester, they erode trust, they poison the relationship, and they can easily lead to, wildcat strikes or major costly arbitrations. By resolving them early, the FMCS acts as this ongoing stabilizer in the workplace.
And they also do proactive work, right? The training and intervention programs.
Yes. 1,566 of those programs. This is the preventive maintenance side of their work. They train parties on things like labor management committees, conflict resolution, communication strategies.
So they're basically teaching management and union leaders how to solve their own problems without needing a mediator down the line.
That's the goal. It reduces the future burden on the federal government.
And then there's the function that is, I think, often overlooked, this infrastructure piece, the arbitration panels.
This is a huge service to the entire industrial relations system. The FMCS provided 9,706 arbitration panels.
Why?
Many union contracts require that if there's a dispute that can't be resolved, it has to go to a neutral third-party arbitrator. The FMCS maintains a roster of these certified impartial arbitrators.
So they're the trusted source for finding a neutral.
Exactly. When a company and a union need an arbitrator, they contact the FMCS, which provides a list of names, a panel, and the parties select from that list. The FMCS vets these professionals and guarantees their neutrality. This service underpins the finality of collective bargaining agreements all across the country.
So if the FMCS is functionally dismantled, where do unions and management go to find these vetted, neutral, certified arbitrators for their thousands of annual disputes?
Well, they turn to the private market. And this brings us right to the economic absurdity of these cuts, because the whole thing was framed as saving federal money.
Right.
So we have to contrast the agency's tiny budget with the immense costs that would be imposed on the private sector and the broader economy if the FMCS wasn't there.
Okay, let's talk about that ROI. The return on investment. What is the actual budget of this agency?
The FMCS operates on an annual budget that's it hovers between $50 and $55 million.
$55 million. For perspective, in the grand scheme of federal spending,
It's less than 0.014% of the entire federal budget. It's a rounding error. It is truly a negligible amount.
And yet, for that tiny investment, what is the estimated financial value they return to the national economy every single year?
The estimated annual economic savings generated by the FMCS, and this is primarily through preventing costly work stoppages, is conservatively estimated to be more than $500 million.
Wait a minute, just repeat that. A $55 million cost prevents $500 million in economic damage.
Over $500 million, yeah. It's a staggering ratio.
It's a phenomenal return.
Yeah.
This is the crux of the whole argument against the cuts, isn't it? The agency generates roughly a 10-to-1 return on investment.
It's one of the very few government functions that demonstrably pays for itself many times over, purely through preventing economic friction.
Let's stop and really unpack the mechanism of that $500 million saving. How does the FMCS generate these silent, massive economic benefits? Give us a concrete example of what a strike actually costs.
Okay, take the dock worker disputes, which the FMCS is routinely involved in. A major strike on the East or West Coast docks doesn't just halt wages for the workers. It cripples global supply chains.
Everything stops moving.
A single day of that kind of disruption can cost the national economy tens of millions of dollars. You're talking delayed goods, canceled contracts, increased shipping costs. There are these massive demurrage fees penalties paid to shipping lines because containers are just sitting there. Perishable goods spoil. Manufacturing plants have to idle because they can't get parts.
And the FMCS's successful mediation avoids that entire cascade of economic failure.
It prevents market seizure. The cost of mediation, a few hours of a professional's time, is just infinitesimally small compared to the cost of those massive market failures.
Which is why the critics, and this includes both management and labor attorneys, people who are usually on opposite sides, they universally condemn these cuts as just fiscally irrational.
They did. They all argued that the negligible federal savings would be instantly overwhelmed by massive new costs imposed on the private economy and on state resources.
Let's play devil's advocate for a second, though. Doesn't the executive branch have some inherent authority to try to meet broad goals like cutting the budget, even if it leads to, temporary tensions like this?
That's a fair question, and it's really the core tension here between executive discretion and legislative mandate. The problem wasn't the goal of cost-cutting itself, it was the execution.
How so?
By withdrawing FMCS services, the government didn't eliminate the cost, it just shifted it. So private companies and unions were now forced to go out and hire extremely expensive private mediators or arbitrators.
At what cost?
Often several $1,000s per day, rather than using the inexpensive administrative framework provided by the FMCS.
So the federal government saves $50 million, but private industry and local economies are suddenly hit with hundreds of millions in new costs for conflict resolution, disruption, and legal fees.
It's a classic negative-sum transfer. The efficiency gain for the federal budget was immediately and dramatically outweighed by the inefficiency it created in the national economy. The critics, and later the judge, saw clearly that this just made no fiscal sense.
The FMCS is silent, preventative infrastructure. Its value is invisible until you try to take it away.
That's it.
To humanize this even more, let's reflect on some of the high-stakes cases the FMCS handled in 2024, just to show the expertise we almost lost.
The source material gives some really compelling examples. FMCS mediators were instrumental in averting strikes at major urban hospitals, like George Washington Hospital, ensuring that essential patient care wasn't jeopardized.
That's a huge public safety issue.
Absolutely. And they resolved critical contract talks for New York utility workers, so they avoided health and safety risks tied to potential disruptions to power and gas services in a major city.
And some of the largest collective bargaining units in the entire nation rely on them.
Without a doubt. They resolved a major conflict involving the nation's largest teachers' union, preventing statewide school closures that would impact millions of families and local economies. But, maybe the best example of their coordination and impact is the Minnesota nurses negotiation.
Remind us of the scope of that one.
That involved mediating contract negotiations for 15,000 Minnesota nurses across 16 different hospitals, all at the same time.
Whoa.
That requires specialized coordination, the ability to manage multiple employer groups, multiple union chapters, and just vast experience in these complex, high-emotion environments like healthcare. And the FMCS managed it, avoiding a massive regional strike that would have swamped healthcare services across the entire upper Midwest.
And they're keeping up with the evolving workforce, too, right? They're involved in modern sectors.
Yeah. They assisted with high-profile, really novel cases, like facilitating the first contracts for newly unionized Apple retail workers.
That shows their adaptability.
It does. And of course, they still handle the bedrock industrial negotiations, facilitating agreements between Boeing and the Machinists Union, and being ever present in those critical negotiations involving the East and West Coast dock workers, the talks that literally dictate the flow of American commerce.
The moment you catalog that work, from a first contract at an Apple store to preventing a nationwide supply chain breakdown, the decision to cut the staff from 143 to 5 shifts, from mere economic illiteracy to an operational guarantee of industrial chaos.
That's the only logical conclusion you can draw. The unions had to act, and they took their case to Judge Subramanian, which sets up the most rigorous part of our deep dive, the legal analysis.
This brings us to part 3. The judge issued a 192-page decision. That length alone suggests a level of detail and rigor far beyond just a simple rebuke. What was Judge Subramanian's legal strategy here?
His strategy was surgical and precise. He chose to rely entirely on the strongest, most stable principles of administrative law and statutory interpretation, primarily the Administrative Procedure Act, or the APA.
And that's crucial because the unions had also raised these huge constitutional questions, right?
Yeah.
Separation of powers, the Take Care Clause, things like that.
They did, and the judge sidestepped them.
Why? Why avoid the constitutional claims?
It's a classic move of judicial restraint. A victory based on constitutional grounds can sometimes be seen as overreach, or it can be easily narrowed or overturned on appeal. By sticking to the APA, the judge delivered this really targeted strike against the policy itself based on technical, procedural, and statutory flaws that are just much harder to defend.
So it's a more robust, unassailable path to victory.
Exactly.
Okay, so before we get to the core of the APA argument, the government tried to throw up a couple of procedural roadblocks. First was the issue of standing.
Correct. The government argued the unions lacked standing to sue. Their argument was essentially that the decision to cut staff was an internal, discretionary executive action. And so the unions hadn't suffered a concrete, redressable injury.
And how did the court handle that?
The court found that the unions absolutely had established concrete injuries. They had clear documentation of canceled and delayed bargaining sessions. That directly harmed their members' statutory rights to bargain and directly compromised their ability to get a contract. That tangible disruption was more than enough to prove standing.
Okay, so that hurdle is cleared. The second, more technical one was about the nature of the policy itself. Did the court agree this was just an internal staffing decision?
No. And this is where the APA becomes the central tool for the judge. Judge Subramanian classified the FMCS policy, both the cuts and those restrictive 250 and 1,000 employee thresholds, as a final agency action.
And that designation is the key, right?
It's the key that unlocks the door to judicial review under the APA. The court determined the agency wasn't just making internal staffing decisions, it was establishing new rules that govern the eligibility of outside parties to receive mandated federal services. And those new rules fundamentally changed the agency's relationship with the public.
And if it's a final agency action, it has to be rational and lawful. Which moves us right into the core failure of the policy, the arbitrary and capricious standard.
This is the operational standard of the APA. It's often described as the requirement for a rational connection between the facts found and the choice made. Basically, agencies have to provide a logical explanation for their policies. They can't just act based on a whim or prejudice or, just pulling numbers out of a hat.
So what was the key fatal flaw in the FMCS's justification for these drastic new numbers?
The failure to provide any rational basis for those specific numerical thresholds. Judge Subramanian pointed out that while the agency cited the executive order's broad mandate to cut costs, that mandate did not provide a rationale for picking 250 employees for healthcare or 1,000 for other sectors. The numbers were completely arbitrary. The agency provided zero evidence, zero analysis, zero data linking those specific sizes to anything. Not the availability of private mediators, not the complexity of the disputes, not the agency's remaining workload, nothing.
So they basically just said, we need to comply with the executive order, so we're drawing a line right here, without justifying why the line was drawn there and not somewhere else.
Exactly. And the judge noted that an agency can't just rely on a vague, generalized mandate to cut costs to excuse its failure to provide a specific justification for how a new policy impacts its core statutory duties. Without a rational, articulated basis for those numbers, the policy was deemed arbitrary and capricious. It was a failure of basic procedure and justification.
Could you contrast that with a situation where a similar cost-cutting policy might have actually survived an APA review? What would the FMCS have needed to do differently?
To survive, they would have had to document a rational connection. For example, they might have needed to produce a study showing that bargaining units under 250 employees in healthcare are already well served by regional non-federal mediation services, or that the cost of serving units under 1,000 vastly exceeds the potential economic disruption they prevent.
So if they had data.
If they had data showing a logical link, even a questionable one, between the specific number and a valid goal, the court would have likely deferred to the agency's expertise. But here, they offered nothing but the broad political mandate. That vacuum of justification is what sealed the policy's fate.
That's incredibly clarifying. Now let's move to the second major legal ground, statutory conflict. This takes us back to the National Labor Relations Act, the NLRA, which creates these mandatory duties for the FMCS.
This is the real substantive weight of the ruling, especially when it comes to the healthcare industry. The court focused specifically on Section 8D of the NLRA, which governs bargaining procedures.
And the NLRA has unique mandatory requirements for healthcare, right?
It does, stemming from Congress's recognition that, hospital strikes pose an immediate threat to life and public health.
So what does that section specifically mandate of the FMCS in healthcare disputes?
Section 8D explicitly requires the FMCS to use its best efforts to assist the parties in reaching an agreement in healthcare collective bargaining. And that phrase, best efforts, is critical. It signifies a non-discretionary, mandatory role.
So how did the court interpret best efforts in light of this new restrictive 250 employee threshold?
The court determined that Congress intended for the FMCS to attempt to assist in resolving all healthcare disputes that threaten to disrupt care, regardless of the size of the bargaining unit. By setting an arbitrary floor of 250 employees, the agency was essentially saying, we will not use our best efforts for the 249 employee units.
Which is a clear breach of its duty.
A clear breach of its non-discretionary statutory duty. They're trying to carve out exceptions to a mandate that Congress explicitly made comprehensive.
So the court just flatly rejected the idea that the FMCS had the discretion to do that.
Completely. Because the NLRA imposes this non-negotiable duty in healthcare, the policy's 250 employee threshold was found to be in direct, irreconcilable conflict with a controlling federal statute. The mandate of Congress always overrides the policy of the executive branch.
So that provides this powerful, two-pronged legal conclusion. The numbers themselves were arbitrary under the APA, and the policy conflicted with explicit congressional requirement under the NLRA. This sounds like a decisive, total defeat for the administration.
It was a classic victory for the rule of law over expediency. The ruling solidified the principle that if Congress directs an agency to do something, the executive branch can't just functionally dismantle that capacity under the guise of general cost savings.
Let's move to the direct impact of the ruling then. When Judge Subramanian issued this decision, what were the court's orders? How quickly did things have to be fixed?
The court issued two critical and immediate remedies. First, he vacated or nullified the restrictive FMCS policy entirely, so the 250 and 1,000 employee requirements just disappeared overnight. And second, and equally important, he ordered the agency to immediately reverse the reduction in force the RAF and reinstate all the laid-off mediators. He ordered them to restore the agency to its normal operational staffing level.
So those 137 specialized staff who had been sitting on administrative leave were legally compelled to return to work and get back to preventing industrial conflict. That is a full, legally mandated restoration of function.
It's a complete restoration of capacity, and this outcome really reinforces the overriding legal principle we've been highlighting here, statutory supremacy.
Let's dedicate a moment to making sure the learner fully grasps the weight of that concept, statutory supremacy, in this context.
Statutory supremacy is the bedrock idea that Congress, through its legislative power, sets the enforceable rules for how government functions. Executive orders, administrative policies, budgetary directives, they cannot override or nullify specific statutory responsibilities that Congress assigned to an agency under law.
The FMCS was established by Taft-Hartley, and its duties, especially in healthcare under the NLRA, are mandates.
They are mandates. They require the agency to proffer services and use best efforts. An executive order focused on cost-cutting just can't erase those specific requirements. The court basically reminded the executive branch that compliance with the law comes before compliance with internal budgetary targets.
So this acts as a robust, essential check on the executive branch. It prevents an administration from achieving its policy goals, like shrinking government, by just defunding or crippling agencies whose functions are explicitly protected by law.
Absolutely. It ensures that the government can't simply render statutes inoperable through bureaucratic maneuvers. If the administration wants to change the scope of what the FMCS does, they have to go convince Congress to amend the NLRA or the Taft-Hartley Act. They can't just do it unilaterally with administrative cuts.
So what about the road ahead? Was this ruling appealed, or is the FMCS restoration now secure?
While the government technically had 60 days to appeal, the sources indicate an appeal is highly improbable. And to understand why, you have to look at the broader context of other related litigation.
Judge Subramanian's decision wasn't the only one.
It was the second major judicial blow to the underlying executive order. Just a few weeks earlier, in November of 2025, a federal court in Rhode Island had already issued a permanent injunction against the same broad executive order that triggered the FMCS cuts.
And that Rhode Island ruling was broader.
Much broader. It covered a larger swath of the federal government, and it forced the executive branch to reverse actions stemming from that initial cost-cutting directive across multiple agencies.
So by the time Judge Subramanian's decision came down on December 30th, the dominoes were already falling.
Precisely. On December 23rd, just days before the SDNY decision. The government had already filed a notice of compliance related to that Rhode Island order. And in that notice, the government stated its intention to comply with the overarching injunction by voiding the underlying policies and reinstating personnel at several federal agencies, including the FMCS.
So the SDNY ruling, while incredibly thorough and necessary, became sort of the legal cleanup that reinforced a reversal that was, practically speaking, already guaranteed.
It solidified the FMCS's position specifically, relying on the strongest legal arguments available, which made the restoration doubly secure. But yeah, the practical outcome is that the crisis is over. Employers and unions nationwide can rely on the certainty that these high-quality, neutral mediation services will continue without interruption.
Let's zoom out now and summarize the broader implications of this entire battle, connecting it back to labor relations and administrative law.
For labor relations, the implications are profound. This ruling reaffirms that the mechanism for statutory mediation, the public's guarantee of stable labor relations, is an enforceable constraint on the government. It ensures that the crucial, non-adversarial role of the FMCS in preventing costly strikes remains protected.
Labor and management can plan and negotiate with certainty that this critical infrastructure will be there for them.
Exactly.
And for administrative law, what is the clear message being sent to all federal agencies?
It's a very strong, very unambiguous affirmation of the arbitrary and capricious standard. The message is clear. If you're implementing new eligibility requirements, imposing numerical thresholds, or functionally reducing services in a way that impacts your statutory duties, you must provide a detailed, transparent, and rational justification for those specific numbers.
Broad cost-cutting is not a blank check to ignore procedural regularity.
Not at all. It reinforces that the government can't arbitrarily defund services that Congress mandated, especially when those services provide such immense protective value to the national economy. It's an affirmation of judicial oversight, ensuring administrative actions meet a basic level of rationality.
So what does this all mean for us, the learner, as we wrap up this deep dive? Let's recap the essential takeaways.
I think we've established three core truths here. First, the Federal Mediation and Conciliation Service is a powerful, silent protector of the economy. It generates a phenomenal 10-to-1 return on investment. The $55 million budget prevents far greater economic damage, which made the cuts economically absurd.
Second, that legal principle, statutory supremacy, it isn't just academic theory. It's the actionable defense of essential services. Congress's specific mandates, like using best efforts in healthcare mediation, will always override broad, generalized executive directives aimed at cost reduction.
And third, from a legal standpoint, the lack of an articulated, rational basis for any administrative policy like those arbitrary 250 and 1,000 employee thresholds is a fatal flaw under the Administrative Procedure Act. If you can't justify your numbers, the court will strike them down.
Ultimately, this case ensures that the mechanism for resolving complex, high-stakes labor disputes stays fully operational. It prevents industrial chaos and protects the public from the economic devastation that unnecessary strikes and lockouts like with dock workers or nurses or utility workers would inevitably cause. The judicial branch upheld stability.
A textbook example of how a few hundred specialized professionals, supported by a clear statute, are critical to managing the daily friction of a trillion-dollar economy.
And here is where it gets really interesting. Our final provocative thought for you to take away and mull over. We established that the FMCS, an agency with a minimal budget, generates a huge economic multiplier, a 10-to-1 ROI. It's silent, preventive maintenance.
Right. Its value is only measurable when you threaten to take it away.
So if this agency's worth is only revealed when its function is jeopardized, what other small, specialized, and often overlooked federal agencies might be producing similar massive, silent economic benefits, protecting public health or safety or economic infrastructure in ways we don't even track because they successfully prevent catastrophe?
That's a great question. We often focus on what the government spends, but this case really compels us to consider the value of what it quietly saves us from spending. What other small, legally mandated services are currently protected by similar statutes, and what would the economic cost be if those protections suddenly failed?
That question suggests that many critical parts of our governmental infrastructure are operating on razor-thin budgets, yet providing enormous protective value. And their true worth is only revealed when they're politically or bureaucratically threatened. The unseen hand of government is often the most critical.
Indeed. It's a good lesson in looking beyond the budget number to the actual function being performed.
That's a deep dive wrapped up. Thank you for joining us, and we'll see you next time.